Law schools should focus on integrating what I would call the philosophically based knowledge programs with practical skills. I cannot understand why anyone would object to integrating an evidence course with a trial course. It only makes sense. I had no idea what my evidence course, I got good grades, but I had no idea what I was doing with evidence until I practiced. It was all just something I memorized, rules. It only makes sense to me to do them together. You need both. An understanding of the philosophy and the history of the evidence code and its practical application. Well, it's very interesting. NETA will probably always be known primarily for its trial advocacy skills. But in trying to figure out what young graduates needed and trying to figure out if there was a really different focus for transactional lawyers and litigators, of course there is. That's the easy answer. But the more complex answer is not such a difference as you'd imagine. Of course, the person putting together a real estate deal is learning different skills and using different forms and analyzing things differently. But both of them need to understand their client's business, basically. Both of them need skills in client communication. Both of them need skills in negotiation, in mediation, in how to problem solve, in project management. There's a whole continuum of skills that are really exactly the same. Beyond that, we found that what is really interesting, because a lot of our skill sets, like legal strategy, are taught to mixed groups of transactional lawyers and litigators, is that one of the things they like most about those courses is they see a problem from the perspective of the other group. They see as they're putting together a deal, and litigation is a possibility if the deal doesn't go right, or if they're looking at it from litigation and wondering how this deal ever got put together, they see the other group's perspective, which is rare in the firm itself. And so the professional development people and the training partners love that. They're very interested that these people have a chance to cross paths. No, there's no reason to wait for this kind of introduction of people interested in transactional law and people interested in litigation. There's no need to wait for them to overlap until they're already practicing. These kinds of courses should be introduced in law school, it seems to me, so that from the very first moment they touch a real client's problems, they're sympathetic to what might happen, to how they're doing now in putting together the deal might be viewed from the litigator's perspective. And so the litigator is sympathetic to the pressures that were put on the transactional lawyer as the deal was put together. Critical.